of the Sixth Amendment Center. The Sixth Amendment Center is a national nonprofit, nonpartisan organization that provides technical assistance to state and local governments in meeting their constitutional obligations to provide right to counsel services in criminal and delinquency courts around the nation. We receive funding from to provide such services through U.S. Department of Justice grants and contracts with state and local governments. In March of 2018, the Oregon legislature appropriated funds to the Public Defender Services Commission through OPDS to study the adult criminal representation system here in the state of Oregon. And the Sixth Amendment Center contracted with OPDS to conduct that study. We asked that OPDS form an advisory group to guide the study. That advisory group was a cross-section of criminal justice stakeholders and policymakers. And also we asked them to select the counties that we would study. Those counties are Grand Harney, Umatilla, and Murrow, which are two counties that share a judicial district, Douglas, Lane, Marion, and Multnomah. The site work on that study was conducted from July to October of 2018, and just this week we released to OPDS a draft report of our findings and recommendations. The draft report is just that, it's a draft. And whenever we produce a document that's over 200 pages with almost 800 footnotes, we believe that there's going to, be a couple of minor inaccuracies and that sort of thing. So what we've asked them to do is come back to us in a couple of weeks with any corrections that they find, suggestions that we'll take into consideration, and we'll produce the final report publicly and through OPDS to you and other members of the public. But at the same time, even as we go through the draft process with OPDS, our findings and recommendations we believe are final, and I'm here today to tell you what those are. So the first finding is that the state of Oregon has created a complex bureaucracy that collects a significant amount of indigent defense data, yet does not provide sufficient quality oversight and financial accountability. In some instances, that complex bureaucracy is itself a hindrance to effective assistance of counsel. Secondly, the complex bureaucracy obscures an attorney compensation plan that is at root the type of flat fee contract system that pits appointed lawyers' financial self-interests against the due process rights of their clients, and B, is prohibited by all national public defense standards. Third, the composition of the Public Defender Services Commission does not adhere to national standards in that all commissioners are appointed by the judiciary, while the legislative and executive branches of government have no equal voice in the commission's affairs. And finally, the current state oversight commission lacks the necessary statutory scope to ensure the state's 14th Amendment obligation to provide effective Sixth Amendment assistance of counsel in every courthouse in Oregon. And because of that, we recommend first that the Oregon legislature should amend statute establishing the Public Defender Services Commission to ensure that the commission members are appointed by diverse authorities such that no single branch of government has a majority appointments. Second, although the Public Defender Services Commission currently has extensive regulatory authority to promulgate and enforce standards, the Oregon legislature should direct PDSC to promulgate and enforce specific right to counsel standards. Third, the state of Oregon should require that services be provided free of conflicts of interest, as is constitutionally required, by abolishing flat fee contracting and other forms of compensation that produce financial incentives or disincentives for lawyers providing effective assistance of counsel. And lastly, with the abolition of flat fee contracting, the Public Defender Services Commission and OPDS should A, pay private lawyers at an hourly rate that accounts for both actual overhead and a reasonable fee, and or B, hire staff government employees for trial level services. OPDS should have the appropriate resources to provide oversight of such a private attorney and state public defender employee system. Thank you very much for inviting me to talk to you today. I'm here to answer any questions.
John, thank you very much. Questions, and I guess There was a presentation that was made to the advisory group yesterday morning, if I remember correctly. It was the day before, whenever it was.
It was yesterday, yes.
Yesterday, okay. Time flies when you're having fun. And what I didn't hear today is some of the outcomes as to where you, and I say you meaning the, let me get to that, Sixth Amendment forum has basically made some determinations as to where we as a state are at. And I'm wondering if you would, I think it'd be worth you sharing some of the perspectives as to where you, based on your research of Oregon compared to other states, as well as to what is required by law.
Sure. So, Senator, some of our findings, basically in terms of the vast bureaucracy that Oregon has established, one of the big findings that I mentioned early on is that despite having a bureaucracy, Oregon as a state cannot ensure that Sixth Amendment obligations are being met in every courthouse in the state. And that our recommendation is that the OPDSC, I'm sorry, the Public Defender Services Commission, statutory authority basically amended to create more authority of the Public Defender Services Commission to set new standards and have the flexibility to create a model that will actually ensure effective assistance of counsel in every jurisdiction. We offer in our recommendations lots of different models for different states that they could look to. So for example, regarding ensuring that there's no longer any flat fee contracting and conflicts of interest, many states have actually gone through those steps to actually abolish those. For example, in Idaho, the state is abolished. Statutes has been amended to ensure that all terms of contracts should not include any pricing structure that charges or pays a single fixed fee for the services and expenses of attorneys. The Michigan Indigent Defense Commission is also statutorily barred for providing local indigent defense plans that also compensate lawyers in ways that create incentives or disincentives to provide effective services. What we found in Oregon is that OPDS's current model of using a case credit-based system can, in many instances, create pressures on the lawyers that are already facing large caseloads and an underpaid compensation plan that, in effect, causes them to have to consider what they are able to take home to feed their own families against the case-related interests of their clients. And so on that recommendation specifically, we think that the legislature should direct that OPDS no longer compensates lawyers in just that fashion, as just one example.
Okay. So, colleagues, let me just kind of put it forward. What we've learned at this point, it looks like the system we currently are using is subject to challenge in court as to whether or not individuals are, in fact, getting the representation that is required by the Constitution. I want to make that as an earmark because it's something that we will need to be looking at, and we will need to be taking steps to address it. There are some ways that we can move forward on this. We'll have more time to discuss that in our appropriate committees, but it is something that I think we as a state need to be looking at before and taking active steps to address, or we're all going to find ourselves on the other side of a lawsuit. That's my perspective.
And to that, Senator, one of the things that we did find, and I touched upon early on, is that currently OPDS does not have oversight over all courts matters. There's a large gap in oversight regarding misdemeanor representation, despite the 14th Amendment obligation of the state touching upon all Sixth Amendment right to counsel services. So there is currently the Public Defender Services Commission has no authority to monitor the way that right to counsel services are provided in municipal and justice courts across the state. That we believe might be your greatest area of exposure to that extent. That's correct, sir.
All right, thank you. Any questions? I see Representative Gorsuch and then Representative.
Mr. Chair. So I don't know if I missed this in looking this over, but does this also touch on juvenile court?
Our study was, our task through OPDS was to study adult criminal representation. However, the same lawyers provide in many jurisdictions representation in adult criminal, juvenile delinquency, juvenile dependency, civil commitments, termination of parental rights. And so it was impossible for us to truly study solely adult criminal representation, even though that was predominantly our focus. Our report does touch upon the impacts that it can have when you have one lawyer providing all of these services. One of the core tenets of Supreme Court case law is that you have to provide conflict-free representation. And we are in many jurisdictions and in Oregon seeing that there could be problems of having the same lawyers providing representation in all of these different case types, because that lawyer also needs to provide effective assistance of counsel in all of these different case types. And a dependency case is extremely different in terms of what's required in the case from an adult criminal representation matter. And so to have the lawyer be equally trained in both case types is it's very difficult to find lawyers who can do that effectively in all case types, and PDSC currently has an obligation to monitor that, and our concern is that they can't.
Okay. Thank you, Mr. Chair.
Person opposed?
Thank you, Mr. Chair. Mr. Chair, the question I have is really, I'm not sure who to direct it, but I saw Wednesday that OPB reported this draft before we got the draft. And I'm a little concerned about that. How did OPB get this draft?
All right, let me try to answer that question. My understanding is the draft itself was marked and embargoed, meaning that it wasn't supposed to be released. There has been a conversation that I've had with OPB as one of the representatives that was here doing an interview. They assured me that they would be looking into that. What has come back to me at this point is that the individual who did the reporting said that they did not receive that directly from anyone within OPB, with Public Defense Services. And so that question is still out there, but I'm not sure how it was distributed, to who received it that could have potentially leaked it. But yes, it's very concerning for myself after hearing the presentation that it had been somehow shared to some level, but even though it was marked embargoed, that it basically came out. And I understand on the rules of journalism that if you receive it from a third or fourth or fifth or sixth party, maybe you don't think it applies, but I also think from my perspective, it really weighs and gives me merit as to what or who I might be talking to in the future as to interviews. Any other questions or comments? Representative Williamson and then Representative Greenlick.
Thank you, Mr. Chair. I just wanted to publicly thank John and David and the Sixth Amendment Center, as well as the people on the stakeholder committee, because we gave you a very tight timeline to turn around a very, very thorough report. So, and to everybody at OPDS who facilitated the research, the interviews, and all of the field work that you all did, I just want to say thank you.
Representative Wilson, if I may, I'd also like to extend thanks to the people who participated in the study. We received enormous cooperation from all jurisdictions that we visited, and we asked a lot of folks late in trying to produce this report in the past 2-3 weeks even, and so people have been extremely helpful to us. And so as outsiders to your state and being welcomed to the state of Oregon, we really appreciate the assistance that we received. Thank you.
Representative Greenlick.
Well, I guess I will acknowledge the fact that we will have time in the future. Will you guys be back to work with us as we go through the implementation report, and then I'll hold questions.
Representative Greenlick, yes, we make ourselves available to assist the state of Oregon in understanding what our report says. As you have a chance to read it, you might have questions for us. Also, you might have questions regarding what other states have done to address some of these issues that we raise in our report. Our report does offer some guidance regarding those states, but you may have questions for more detail. It's just the broadest of brushstrokes in the recommendations as to things that you can consider going forward, and we make ourselves available to you.
They'll be back.
And Representative, one thing that I had the same question with them before we had the hearing today. They're under contract basically to give us the final report. They've, as John has said, asked the members to get comments back to them within about a 2-week period so they can have that report done before the end of the year, for it will be to us. After that, I expect and I hope there's going to be some discussions of maybe having them continue to do some additional work with us. We have some other questions that need to be answered before that can be decided, but I expect that there'll be some, and they've already offered to give us some assistance, but I hope that we can formalize another agreement to assist us to move forward on this.
I have some conceptual questions, and I have some very practical questions, I think.
I would suggest
we have some time.
Yeah, what I would suggest is that maybe you formulate those questions, and then you can either get them to us or to me, Chair, or to Eric, and we can figure out what we can do at that point to try to get answers to those.
Thank you.
Any other questions or comments?
Just, Mr. Chair, I have a question.
Yes.
Is the report on OLS?
I
didn't see it.
The report being on OLS, I don't believe it is, or what?
It's not.
It's not.
Okay.
It was issued as embargoed. Let's get the certified smarts.
OPDS. I expect with the editing process that we're going to go through, we have a deadline of the 28th of December for comments to come into our agency, and we are expecting the Sixth Amendment Center to publish and release it to us in early to mid-January. So before session, we will make sure everyone on this committee gets a copy.
Any other questions? John, thank you very much. Safe travels.
Thank you very much.
You bet. And our last of our presentations that we have for today is on the post-conviction DNA testing. We have our own Senator Thatcher and Representative Peluso to start off. And we'll let you want to go down? Okay. And then we'll follow up with one other panel after that, Michelle Feldman and Jared Richardson.
Hey, how are you? Glad you're here. You go first or what? You. Mr. Chair, members of the committee. For the record, I'm Kim Thatcher. I'm a senator from District 13, which starts, I'll say, in the south part of Kaiser and goes up to the south part of Hillsborough. And I just want to briefly say that we are, I can maybe speak for you on this, that we're here to promote a bill coming to the legislature in 2019 that I am very excited about, and I wouldn't be surprised if we get a supermajority on both sides of the aisle in both chambers to sign on to this and vote for it. And it aims to make sure that people who are in prison are truly there because they should be, and those who are not, this helps provide them an avenue to prove that they are innocent. Representative Peluso and I have worked together on the task force, the testing of assault forensic evidence kits. I missed the meeting earlier this week, but it has been very successful. We're very proud that the DNA testing from this work has helped keep rapists off the streets, get them off the streets, and DNA testing, you know, we found it to be a very valuable tool. It helps ensure that we are using the best evidence to capture criminals, but it also serves another purpose in that it can help prove innocence. The bill that we are about to talk about today has a very